Hello and welcome to the EU AI Act podcast, your go-to resource for understanding the European Union's legislation on artificial intelligence. I'm your host, Mark Kelly, and I'll be your guide through this intricate landscape of AI regulations that could shape the future of technology in Europe and beyond. In each episode, we'll delve into the EU AI Act, exploring its purpose, implications, and the roles of those involved. From AI developers to deployers, our mission is to demystify how this groundbreaking regulation impacts everything from high-risk AI systems to everyday applications that influence both the physical and virtual realms. Whether you're a developer, deployer, or simply curious about the future AI, this podcast will equip you with the insights and knowledge needed to navigate the ever-evolving world of AI regulations. Stay tuned as we explore these topics and more, helping you to stay informed and ahead in the rapidly changing field of artificial intelligence. Don't forget to subscribe to the EU AI Act podcast on your favourite streaming platform to never miss an episode. It's Mark Kelly here, and very hope you're doing well wherever you are in the world today. And we are speaking about the EU AI Act and regulation. And we're going to have kind of more of a practical session today. We're not going to go deep dive into too much detail in terms of all the nitty gritty on it, but we are going to speak really about what's happening in the market now, what the expectations are around the EU AI Act, and most importantly, if you were not aware, last week it was published the final text, and on the 1st of August, it's now coming into law. And we've got Brian McElligott joining us today. And Brian's a partner at Mason Hayes Curran, and he's also head of artificial intelligence there as well. Brian, thank you very much for joining us today.
Thanks very much, Mark, and thanks again for having me. I'm always delighted to contribute to AI Ireland. You know, we're big supporters of you guys, and we absolutely love what you do.
Thank you again. And I'm always interested when you're posting on LinkedIn, because there's a lot of noise around the EU Act. If you don't feel overwhelmed, you haven't seen all the brochures and all the text, because if you did, you would. So we have the final text now published. We've got August the 1st as this kind of D-Day where things kind of start to kick in. Could you remind people listening in, business owners or people working, predominantly in actually a variety of different industries, what is this EU AI Act and what do people need to start to take note of?
Yeah, and you know what, that's a very good perspective, because often it's very easy to get lost in the detail of the legislation, especially when you see an awful lot of very detailed updates coming at you. So sometimes it's good just to take a step back and go, what's this whole piece of legislation about? And I think the first thing that should be noted, and it's one that I often talk about, which is this concept. What is the concept of the AI Act? And I would say that it has a lot more in common with product safety law in the EU than the GDPR. And the GDPR is often viewed through the lens of fundamental rights, protecting the fundamental rights of the data subject. Whereas the AI Act is actually all about product safety. So if you're thinking about the AI Act in your mind and frameworks, I would think about things like toys, lifts, medical devices, things like that, and how the EU treats them. So in your mind, you're thinking about things like, market surveillance and CE marks and all those sort of aspects that go with product regulation. Another aspect of it, I think, that's very important to be aware of is don't get too bogged down in the names used for the various categories and the risk categorizations. First off, there's majority of the law itself deals with AI systems. It also deals with models, which it calls general purpose AI models, or, the area of Gen AI, but it's actually primarily targeted at AI systems. And it treats them in a particular manner. And this is this kind of well-known kind of risk categorization process you'll have heard about a lot in the market, where it sets out 4 broad risk categories. And when we're talking about these, what we're saying is, the EU, through the lens of this piece of law, looks at the market and says, we think broadly there are 4 types or 4 classes of uses of AI that get categorized into banned AI, high-risk AI, limited risk AI, and low-risk AI. And their view on that is they don't want to regulate AI across the board. They see that as damaging. What they want to do is pick certain use cases and legislate or regulate those on the basis of the use, and say, something like the use of emotional inference technology in the workplace is banned. They can see that that is incredibly risky. Then they say something like, well, if I put an AI into a medical device, an AI system into a medical device, well, a medical device is already highly regulated. We're going to regulate that as high risk. One thing I would kind of stand back at that point and say is, high risk is a little bit of a misleading sort of a name, because high risk kind of conveys, danger. I think a more accurate categorization of that product would be regulated AI, because these are categories of risk or uses of AI that the union is stepping in and saying, we're going to regulate these pieces of software as if they're hardware, and we're going to make you, go through a conformity assessment like those in the medical device area go through before you launch it. And once it's launched, we're going to put a regulation on you, or an infrastructure to manage the risk of something going wrong once it's on the market. So I think, high risk, think regulated AI. And then you're into other things like limited risk AI, which is all about the concept of transparency, and putting forward information so that others who engage with your artificial intelligence can build systems themselves in an informed manner. And I think there are a couple of things that are emerging actually as we're looking at the market with our clients, and they are looking at compliance and compliance planning. And the main one actually is a relatively well-known aspect of the law, in that it is a little bit like a cheesecloth. There's a lot of holes in there, and the holes are, lack of specifications and lack of detail. And it's proving to be quite challenging. If I maybe give you an example, let's just say, for instance, you are a creator of an AI system that's going to be used in the HR employment space, which seems to be a really common one these days. That's more than likely going to be classed as a high risk, or one of these regulated AI products that has to go through a pre-market and a post-market type regulatory regime. There's a lot of aspects of that, let's say, conformity assessment pre-market that are causing issues with regard to, what exactly do they want to do here? How much do I have to do over there? How much human oversight is right? How much do I have to do with my data and data governance? What do I have to do from a cybersecurity and a robustness perspective that I'm not doing already? The level of detail with regard to compliance is not amazing. And we're waiting on these associated standards that are supposed to come out in the next about, I suppose, 9 months or so. A draft, we're supposed to see of those. But, as you're progressing towards a deadline of August 2026 to have all of your products compliant by that date, it can be incredibly challenging to be, moving within a big organization with a product roadmap towards a deadline, trying to comply, and somebody's saying, oh, we just need to wait for one more thing, and you're waiting for the one more thing to come to give you guidance. And that's kind of a common piece of feedback we're getting at the moment from our clients.
Yeah, and it's a challenging one because the regulation came, and we know that 40 out of the 50 states in the US are introducing some type of regulation as well. And, a lot of big tech are asking for this. This is something that, I suppose, the technology has moved so quickly that people have probably been surprised by how advanced it's actually got. So for organizations, they have to start getting their head around something that, from a practicality perspective, how you're going to start to enforce this, and know that you're ticking the boxes, not like you're going up with a kind of a standard checklist that you can work off. It's a lot more kind of complicated and nuanced than that. But I suppose you also have the base that will now need to be audited, and you need to be able to kind of show a clear line of sight that if you are audited, you can show your decisions and how you made those decisions. So it's interesting that some countries are kind of offering these kind of sandboxes to kind of give you more opportunities to try to figure that out. And that's probably going to be important to see if you're on the right side of the kind of the law as it is. And I always think of the rugby kind of analogy where the referee's kind of helping you, tell you to stay on side and kind of marshal you until otherwise they give a penalty. And that's probably not the same in soccer. So I'm not sure if that's the right analogy to use.
No, you're right. And actually, it is quite a good analogy. And that kind of, let's say, kind of safe environment of a regulatory sandbox could be incredibly helpful. And, you know, I suppose there's aspects of a sandbox that are kind of quite restrictive in that in order to set up a regulatory sandbox, you have to choose a sector because you're going to have to resource the sandbox with experts who will be able to look at the technology that's coming through in light of the laws and be able to say, do this, do that, like you say, the analogy with the referee. So, I don't think it's the case that we could just throw up multiple sandboxes because they're expensive and they take time to get up and running and you have to have dedicated expertise. But, in Ireland, we're known for certain things, in the area of like fintech and med tech. So there are opportunities there. And, there is a central bank fintech type sandbox already in place. I don't know the extent of which, it's active or engaged with the market, but there is a framework there. And I would think that perhaps if it was resourced to another extent or in a different way, in a different manner, perhaps that could be a good example of where we could pour resources into. We're generally, apart from the multinational market, we're generally a nation of SMEs. You could put a few through that sandbox and see how it goes. I think it would be a useful experiment.
And when you look at some kind of practicality, there is the expectation within the next 6 months for training for employees regarding AI.
You're right. And this is Article 4 of the law, which specifies kind of quite broadly that all of us who are using, either creating or using AI in our organizations need to have like what they refer to as sufficient level of AI literacy of their staff and other persons who are dealing with the operation of those AI systems. The law isn't incredibly specific about what that looks like. And it's funny, one of our clients who is like an AI producer themselves asked us like, oh, do we have to do this? And I thought about it and I was talking to them and I was going, well, you are the lawyer in there who knows a lot about this. The only other employees in your company are either also lawyers in the same area or they're all engineers or data scientists. So I'm thinking, I'm not massively sure about how much, training you guys need to do. You're probably going to be delivering the training to us. So I think it's going to be a horses for courses type thing. So, the company that's bringing in, let's say, examples of HR tech that might be high risk in the future, they might have to do a little bit more around their training. Whereas someone who's using, let's say, Microsoft Copilot or kind of open models, LLMs, they might just have a lighter touch. But your overall point is bang on. Like, by the 2nd of February next year, we all have to have this in place.
Yeah, and from my perspective, what I see day to day is companies are using Shadow ChatGPT or Perplexity or Gemini, and there's a lot of sensitive data being put out there. So as a starting point, companies should have an AI policy, and that AI policy might be very, very straightforward in terms of what you do and what you don't do, and what the company stands for. But at least people know the rules of the road, because what we're finding is that it fluctuates between 30 to 35% of these shadow ChatGPT users where they're using it. And a lot of the times they're a lot more productive by using it, maybe saving between 1 to 3 hours per day. And then some of the colleagues aren't using it. Now, that starts to become a little bit of an elephant in the room, right? Because if you start getting promoted on the back of it, or suddenly different types of questions will be asked. So it'll be interesting to see if companies start to go on this journey and get ready for that, because that for me would be a low-hanging fruit for them to start off and actually start to put out the parameters of using it. Because there's probably, from the survey feedback with Microsoft and Trinity, I think it was around 75% of employers or employees are using AI in some regard day to day, off the shelf type of products. And with those off the shelf products, we've seen with companies like Adobe, they're updating their terms and conditions. Some people are knowing about their terms and conditions change, being trained on the data. So you need to be aware of that. Now, on the recruiting or software side of it, there's companies that are using AI to, for video interviews, things like this, and tracking that, and applications, filtering through and saying who should go forward or not. Again, making sure that those products and services that you're paying for are adhering to the EU AI Act, or there's a roadmap to adhere to that EU AI Act. Because if not, you will be fined as well as the company. So this is where we've kind of got those innovators and deployers, and there's a few different stakeholders in play that you need to understand which hat do you actually wear. It's not as simple as saying, well, the dog ate my homework.
You're right, no, and it's a really good point. In that a lot of people may mistakenly think, oh, maybe I have this AI literacy kind of training type obligation in my organization, but sure isn't everything else for the creators of the models and the AI systems. You're bang on. I mean, there are obligations in there for what they refer to as everyone in the AI economic chain, which is everyone from the creator down to the end user who is a business user, not a private user. So everybody who's in an organization, they do need to think about, well, what am I using from an AI perspective? What type of AI is that? How might that AI fit into these categorizations in the EU AI Act? And what am I? Am I a creator or am I a user? Because depending on your place, and by the way, you can be both, and you could be both for one product or both for different products. And you have different obligations, and obviously the creator is the ones with the greatest amount of obligations, but as you say, the user, who's called the deployer under the Act, has their own set of obligations. But again, I would kind of pull back and go, it's mostly in relation to these high risk or regulated products that you have these definite obligations, and if you fail to meet them, you are subject to penalties.
Yeah, and as things start to flesh out in terms of the compliance and the metrics, and some of those holes get kind of filled in on that kind of cheese board example you said, companies will start to feel more comfortable. But I think as a starting point, we talked about the policy, but also, in the world, years gone by, it was kind of the shadow IT, where companies have got different types of systems and policies or products being purchased by their employees. Now it will be, well, what AI products do we have as these kind of shadow products? We need to make sure we're adhering to them, and we need to understand what we're signing up for day to day, because of the kind of the data risk that's there as well. And I almost think that, for your perspective, we're thinking about that regulation, innovation, stifling conversation that happens quite regularly. But what we're seeing now in the US from the FTC is they're aggressively going after companies and actually saying, we feel this is a breach, we're now going to investigate that. And that's, where I see they're probably a lot more going to enforce, rather than Europe. Sometimes they can be that kind of delayed approach. I'm quite interested to see some of these copyright cases, what happens and the impact of them, what happens from the people that actually say managing and mining the data, because a lot of the companies will take people's data for one purpose, but then they're actually using it for a completely different purpose, which AI is trained for, to provide different services, but maybe you have not signed up in that regard. So it starts to get quite complicated quite quickly.
Oh, it is, and it's incredibly complex, and like you hit on a number of points there in the area of copyright infringement, model training, privacy, data privacy laws. And there is a lot happening in all of those spaces right now, and they are moving at 1,000,000 miles an hour. I mean, just take a couple of examples. So yesterday, I think it was even just today, I read an update about one of the cases in the US court that you're referring to, which was developers who had provided code previously under open source licenses. They were making a claim that Microsoft via GitHub, or actually I don't know if I got the parties right there, were infringing it by using it to train their models. And it seems that like a chunk of their action was just dismissed yesterday. So the court said, no, you're even not making the right case, or we're dismissing your action. So that case has been narrowed significantly. When it comes to things like data protection, there was an incredible update. Well, in my mind anyway, incredible update from the Hamburg Data Protection Commissioner yesterday in Germany. And I think it's incredible and useful because in very plain and simple terms, they're starting to say things like, we are of the view that a model, and now when I talk about a model, I'm talking about a model in a very kind of abstract sense, rather than, let's say, the AI system that you and I would interact with. I'm talking about the model behind it. They're saying that the model on its own, if no data is being passed through it, does not have personal data. And that's actually an incredible update, because up until now, a lot of people would have, like me, giving advice to clients, would have been scratching around going like, I think this is the answer, but I'm not, technically able to give that, absolute defined answer. And unless and until a regulator or a court comes out and says it, we're on the back foot. So this area is like, it's rapidly changing by the day, and there are useful decisions coming out everywhere. Well, sorry, some of them are useful, some of them not so useful.
Yeah, and then you're trying to hedge your bets depending on people's view, because as you explained that argument there, I could see how you could go to either side of it, and you could articulate it in a different way as well. So we've got the EU AI Act now, which is published in the official journal. So that happened, and it comes into force on the 1st of August. And then winter 2024, according to the article 113A, the prohibitions in Article 5 become applicable in the EU. And then, according to the Article 113B, the GPAI provisions in Article 51 FF become applicable within the EU in 2025. So we've got other things to happen in 2026 and 2027, but they're probably the ones that we probably should spend the most time on, or just thinking about those kind of next kind of poles in the sand.
Absolutely. And the first one being the date of the 2nd of February in 2025. Rather typically of the EU, they came out with a little bit of a curveball in their dates. They said that it was projected that the Act would come into force on the 1st of August, which it did. And then it was projected that the dates would roll 6 months, 12 months, 24 months, 36 months. But the EU decided that they would go 6 months plus 1 day, 12 months plus 1 day. So everything is actually rolling from the 2nd of February, the 2nd of August 2025, the 2nd of August 26, just to keep us all on our toes. And yeah, key dates are, let's say, next February 2nd, we have this date when the shutters will come down in the EU on the banned, there are 8 examples of banned AI in Article 5, if anyone wants to go and read them. The emotional recognition one I was giving earlier. Then there's another big deadline coming up for the people who provide these models in the 2nd of May next year, when we are due to receive codes of practice about how these models, their obligations can be met, on some information about that. Then the 2nd of August next year is actually, it's an odd deadline, because it says that if you have provided a model to the market before this deadline, you're not going to be liable for compliance until the 2nd of August 2027. That's 3 years. But if you provide your model the day after, you must comply straight away. So you can see this kind of what you call like a grace period, and people may be rushing to put models on the market. I don't know if it's actually going to transpire that way. And I'm talking to a few clients about that right now, and they're finding it all a bit perplexing, to be quite honest. And then you have another deadline, another huge deadline on the 2nd of August 2026, when this concept of high risk AI in the likes of HR, education, biometrics, etc., that's going to come in. So they're kind of roughly the big dates that are coming up. And a lot of companies that I'm working with anyway already have their roadmaps ready. They're on the go. Some are less prepared. Some haven't even started yet. I guess the big question for everybody is the unknown with regard to what does compliance look like, and can we get it done in time? Because it's quite a new thing for people in the tech space.
Yeah, and the advice I'm offering to people is once you've got a roadmap, you're engaging with different departments, you're putting out your best foot forward, and you're working through that kind of golden thread across the organizations, and you're bringing it there. It's kind of like the cybersecurity. You're never going to be 100%
Yeah.
safe, secure while you're on this journey. There's going to be those elements of doubts and risk and worries, but I suppose you're just trying to show how that if it was audited, your clear thought process, your processes. And ultimately, you want that human-centric privacy by design, and that kind of all that stakeholders involved, that you've had ethical decision making throughout it, and then you can put your best foot to say, listen, this is how we made our decisions, this is how we approach this, this is how we've tried to show governance, compliance, and then step by step, we'll start to get more certainty around how this plays out in the real world too. And I suppose the advice I'd probably share is to get started on that roadmap. But as you're seeing with companies, it's probably only when you're actually on the journey do you actually start to see the difficult questions you need to start to
Yeah.
answer.
Yeah. Oh, that's such a good point. I mean, it's only when you get into the details you start to understand, the scope of the journey in front of you. It's funny actually that there's a couple of clients, particularly in the US, have said to us that, they are up and running with their compliance plans, and we're helping them with, mapping the legal piece onto what they will call their responsible AI piece. But they're gung ho. They've allocated budgets. They're raring to go, and their view is, it's inevitable. They're going to have to comply anyway. They don't see these arguments of we'll have a US product and we'll have an EU product. Now, I know there are other arguments out there and other companies doing certain things. But some of these companies argue that if we are able to reach this, so-called trustworthy AI CE mark standard as quickly as possible, we're going to differentiate ourselves in the market. And we're actually going to use this as a sales pitch. So it's an interesting argument to see. Not everybody uses it, not everybody's engaged on that side, but it's an interesting one to see.
Yeah, I do think that is an interesting one. But it's funny, I had a conversation about this recently where you have that CE mark. It's almost like, get that plug and it's safe to use. But the thing about AI is it's training and learning each day. So what it is tomorrow, is it still safe? Is that mark still relevant?
Yeah.
Because you've kind of gone into the wilderness again in terms of it's advanced so quickly. So that's where I start to question.
They have you covered there. So you have this concept of change control procedure built into not only the legislation here in the AI Act, but also a lot of these organizations would do it. So they would say, as part of my application for the conformity assessment, I am going to tell you the level of predetermined change that's going to be, built into my product as it goes. Now, the certificates won't last forever. They'll only last for a few years. You're going to have to look at it again. But I think, there'll come a time when people will get over the initial hump of trying to, feel our way into what compliance looks like, and they'll get more sophisticated with it. And they'll be able to plan and project forward a little bit easier. And then, what we're seeing actually with some clients is being able to kind of borrow from other sectors or other jurisdictions, which already have slightly better controls or guides in place. And that kind of predetermined chain control procedure is something that's issued by the FDA in the US under medical device law. And you'll see people kind of borrowing concepts from that to try to help them with compliance under the EU AI Act. So there's a lot going on, let's say, from a detail perspective in the background.
Yeah, and there's a lot of different frameworks and kind of foundational work that's out there that will provide you with that kind of a roadmap to feel more confident in how you're approaching it. But the devil's in the detail, and as you kind of work through that as well. It's a topic that we can go into so much more detail. But I think this is a really nice leveler just to actually acknowledge what happened. With the 1st of August coming down the track, I think it's important for people just to start to think about it becoming real now as well. Brian McElligott, partner and head of AI at Mason Hayes Curran, thank you very much for joining us on the show today.
Thanks so much, Mark. Really appreciate it.
If you're as passionate about the intersection of AI and regulation as we are, then you'll want to dive deeper. That's why I'm excited to introduce the EU AI Act online course. This comprehensive course is designed to arm you with a thorough understanding of the EU AI Act and its implications across industries. Whether you're an attorney, a compliance officer, a developer, an executive, or a regulator, this course is everything you need to navigate the complexities of AI regulations. Over 3 hours of on-demand video and 6 detailed articles await, all accessible forever on any device, be it your phone, tablet, or TV. Enroll today to secure unlimited access and take the first steps towards mastering the intricacies of AI regulation. Just visit courses-ai.com to get started and stay ahead of the curve and understand the impact and lead with confidence in the age of AI. Don't miss out, your deep dive into the EU AI Act starts here.